In the heart of the winter of 1946, when Europe still lay prostrate under the weight of 6 years of total war, in a small town in eastern France called Belfort, still marked by the deep scars of war, a man was shot at dawn against the cracked wall of a military barracks. The temperature that morning had dropped below zero, and the ground was covered with a thin layer of frost that crunched under the boots of the firing squad. His name was Henri Marchand. He was 32 years old, with brown hair that was beginning to thin, green eyes that his sister said reminded her of their father's. He had been condemned for desertion in wartime. The sentence had been carried out with bureaucratic efficiency, without fanfare, without witnesses beyond those required by military protocol. A chaplain who had murmured prayers that Henri had not listened to, a medical officer who had certified the death with a nod of his head, and 6 soldiers who had fired with trembling hands, some of them deliberately aiming high so as not to have the weight of an execution on their conscience. But there was something deeply, viscerally wrong with that execution, something that would haunt a nation's conscience for decades, something that would transform a wartime death into a symbol of injustice destined to resonate through the halls of European courtrooms for generations. Henri Marchand was not a deserter in the traditional sense of the word. He had not abandoned his post out of fear. He had not tried to flee from the front to save his life. He was a decorated soldier. He had fought valiantly during the liberation campaign of France. He had received a medal for valor for saving 3 wounded comrades under enemy fire during the Battle of Colmar. But on March 17, 1945, he had abandoned his post to save his mother from an imminent bombardment, after receiving word through a civilian messenger that his native village, a small cluster of houses near Mulhouse, was under attack by a retreating German unit that was destroying everything in its path. Henri's commander had denied him permission to leave, explaining that there were no men to spare at that critical moment of the battle. But Henri had made the most human, most understandable decision that a son could make. He had fled into the night. He had traveled 35 kilometers on foot through bombed roads and minefields. He had arrived at his village just in time to find his mother hiding in a cellar while the houses around her burned. He had brought her to safety at a nearby farm, and then he had returned to his unit 3 days later, spontaneously, exhausted, with bleeding feet, ready to accept any disciplinary punishment. Instead, he had been tried under an emergency decree issued in the chaotic final days of the war, a decree that the French provisional government had promulgated to stem a wave of desertions that was threatening the cohesion of the army. It was Decree number 348 of March 23, 1945. A text of barely 3 paragraphs that provided no clemency, admitted no mitigating circumstances, made no distinctions between those who fled out of fear and those who left for compassionate reasons. It transformed every unauthorized absence into a capital crime punishable immediately by death. Henri's trial had lasted less than 2 hours. The military tribunal was composed of 3 officers who did not know him, who had listened to his commander's testimony, who had read the prosecution's report, and who had deliberated for 15 minutes before pronouncing the death sentence. The court-appointed defense attorney, a young and inexperienced lieutenant named Dupuis, had stammered a few words about Henri's previous good conduct, about his courage demonstrated in battle, about the human motivation of his act. But he had been interrupted by the tribunal president who had declared, "The decree is clear. There are no exceptions. The sentence is death by firing squad, to be carried out within 24 hours. Henri had listened to the sentence standing, with his hands tied behind his back, without saying a word. The only thing he had asked was to be allowed to write a letter to his sister Marie. He had been granted a sheet of paper in 10 minutes. He had written, "Marie, forgive me for leaving you alone. I did what I had to do. Take care of Mother. I love you. Henri." The letter had arrived to Marie 4 days after the execution. What made the injustice even more atrocious, even more unbearable, was the post-war sentence. When the Marchand family, devastated by grief and incredulous at such an absurd death, requested a review of the trial in 1947, arguing that Henri had not received a fair trial, that the decree was disproportionate, that he deserved at least posthumous recognition of the fact that he had acted out of love and not cowardice. The military appeals court rejected the request with a ruling that chilled the blood. The decree was in force at the time of the act. The execution was in conformity with military law in force. The execution was legal. No mercy. No recognition of the humanity of Henri's act. No consideration of the fact that the war was now over and that perhaps it was time to look with different eyes at those terrible days. Only the cold, implacable application of a law that, in the words of the military judges, could not be questioned retroactively without undermining the entire system of military justice and the discipline of the armed forces. How could this be just? How could a system that proclaimed itself liberated from Nazi tyranny, that had fought a war in the name of freedom and human dignity, continue to defend such a brutal, such a blind sentence? How could the judges, men who probably had their own families, their own mothers, look at the documents of that case and not feel even a shiver of empathy for a man who had chosen love for his mother above military discipline? The answer to that question, an answer that would require 8 years of obsessive research, of sleepless nights spent studying incomprehensible legal documents, of journeys across Europe in search of evidence hidden in the dusty archives of governments and international organizations, would be sought with a determination bordering on obsession by a woman whom no one would ever have imagined could challenge the entire French military judicial apparatus. Her name was Marie Vidal. She had taken her mother's maiden name after her father's death. She was 27 years old when she began her impossible battle against a system that seemed specifically designed to repel people like her. She was neither a famous lawyer nor an investigative journalist with the resources of a major newspaper behind her. She was just a young woman with a literature degree from the Sorbonne, a woman who had lost everything in the war. Her father had died in 1940 during the collapse of France. Her brother had been shot in 1946, and her mother, the same woman Henri had desperately tried to save that March night, had died a few months after her son's execution, consumed by grief and the shame that society had cast upon Henri's memory, unable to bear the weight of being the mother of a deserter. Marie had been left completely alone in the world. In that total solitude, in that void that threatened to swallow her every morning, when she woke up in her small apartment in the Marais, where the sounds of the city reminded her that life continued indifferent to her pain. She had found a purpose that would define and consume the rest of her existence, to prove to the world, to France, to history itself, that her brother had not been a coward, had not been a criminal, but had been murdered by a state that had betrayed its own fundamental principles of justice at the moment when that justice was most necessary. But no one wanted to listen to her. Post-war France was trying to rebuild, to look forward, to forget the most uncomfortable and painful aspects of the war, raising questions about military executions, questioning decisions made by men who were still in power, suggesting that perhaps the government had been wrong. All of this was seen as unpatriotic, as an act of betrayal toward those who had sacrificed everything to liberate the country. When Marie submitted the first formal petition for review of the case in 1947, spending weeks writing it by hand because she could not afford a typist, the lawyer who had initially agreed to represent her, an elderly man named Maître Blanchard, who had a small law office near the courthouse, abandoned her after the first preliminary hearing, claiming with sincere dismay that the case was politically impossible, legally hopeless, and professionally suicidal for anyone who decided to pursue it. The local newspapers to which Marie had sent Henri's story, hoping that public opinion might pressure the authorities, refused to publish it. The editors explained to her on the phone, in tones that oscillated between embarrassment and irritation, that it was not the right time for this kind of story, and that readers were not interested in reopening war wounds. The war veterans with whom she tried to speak during commemorations and rallies, hoping to find allies among those who had fought alongside Henri, treated her with a mixture of embarrassment and open hostility, as if she were profaning the sacred memory of the liberation by raising uncomfortable questions that called into question the justice of the system that had won the war. A retired colonel, a corpulent man with gray mustaches, and a collection of medals pinned to his chest, told her loudly during a public meeting organized by a veterans association, with dozens of people present who nodded in agreement. "Your brother was a coward, miss. He abandoned his comrades at the moment of need. Military discipline is the only thing that holds an army together in wartime. Without that discipline, we would have been defeated. You should be ashamed to defend him. You should be ashamed to come here to tarnish the memory of better men who died at their posts." Marie listened to those words with her face burning with humiliation and anger, feeling all eyes in the room fixed on her with disapproval. But she did not lower her gaze. She was not ashamed. She would never be ashamed to defend her brother. And she would never, ever give up. No matter how many doors were slammed in her face, no matter how many times she was rejected, mocked, or insulted. The first 3 years of her research were a desert of frustrations and systematically closed doors. Marie had understood, with a painful but necessary clarity, that to overturn the sentence against Henri, it was not enough to appeal to human compassion or invoke abstract moral principles. The judges were not interested in her feelings. They were not moved by her tears. She had to speak their language. She had to prove, with irrefutable documentary evidence and rigorous legal arguments, that the military decree used to condemn Henri had been applied illegally, or better yet, that there existed a superior legal norm, recognized by international law, that completely invalidated it. But how could a woman without formal legal training, without significant financial resources, without connections in the academic or judicial world, and without allies willing to risk their professional reputation to help her do this? The answer Marie found was simple in its formulation, but extremely difficult in its execution. She had to study the law on her own. She had to become her own lawyer. She had to transform herself from a literature student into a self-taught expert in international military law. Marie began to attend daily the library of the law faculty of the University of Paris, of an imposing building with high ceilings and endless rows of shelves that seemed to touch the sky. She spent entire days, from early morning until closing time, completely immersed in dusty volumes of military codes that no one had consulted in years, government decrees published in official collections that required hours just to locate, and collections of war jurisprudence written in technical language that seemed designed to be impenetrable. At first, legal language was completely foreign to her, so different from the literary prose she had studied at the Sorbonne that it seemed almost a foreign language. The sentences were written in extremely dense paragraphs, full of intertwined subordinate clauses, of references to norms she did not know and had to go search for in other volumes, of precedents cited with incomprehensible acronyms that she could not trace without the help of a patient librarian. But Marie was deeply, unshakably stubborn. She had inherited that stubbornness from her father, who had been a worker who had never given up in the face of difficulties. Every evening she returned to her small apartment in the Marais, a studio on the 4th floor without an elevator, where the heating worked poorly, and where in winter she had to sleep with 2 blankets, with a heavy pile of scribbled notes that she herself struggled to reread. She spent the night hours, often until 2 or 3 in the morning, sitting at the kitchen table under a weak lamp, patiently trying to decipher what she had read during the day, to connect the pieces of a legal puzzle that seemed to have no solution. Slowly, painfully, with a frustrating gradualness that often made her doubt herself and the possibility of succeeding, she began to understand the complex structure of the legal system that had killed her brother, to see the contours of the labyrinth she had entered. The first document she analyzed in depth, word by word, comma by comma, was the decree itself that had condemned Henri to death. Decree number 348 of March 23, 1945, issued by the French Provisional Government in the confused final days before the final German surrender, when the French army was fighting its last battles on German soil, and desertions were becoming a serious problem, threatening to compromise troop discipline. Marie found the full text of the decree published in the official journal of the French Republic, preserved in huge leather-bound volumes in the archives section of the library. The decree was extraordinarily brief, almost brutally concise, as if whoever had written it had wanted to eliminate any ambiguity or possibility of interpretation. It consisted of 3 articles, for a total of perhaps 150 words. Article 1 stated with glacial clarity, "Every French soldier who abandons his post in the operation zone without written authorization from his direct superior will be considered a deserter and will be punished by death by firing squad." Article 2 specified the procedure. The trial will be conducted by a military tribunal composed of 3 officers. The sentence will be executed within 48 hours of its pronouncement. Article 3 added, "This decree enters into force immediately and remains in force until the cessation of hostilities." There were no exceptions listed in the text. There was no explicit mention of mitigating circumstances that could be considered. There was no appeal procedure described or even hinted at. There was no room for compassion, for understanding individual motivations, for recognition that war produced impossible situations where every choice was wrong. It was a legal weapon as sharp as a guillotine, designed with cold efficiency to instill terror in soldiers and maintain iron discipline in an army that was fighting its last desperate battles against a retreating but still dangerous enemy. Marie understood immediately, with an intuition that hit her like a punch in the stomach as she sat in the silent library, surrounded by students, studying unaware of the drama she was reliving, that this decree was the beating heart of the problem, the poisonous root of the injustice that had killed Henri. But she also understood, with equal clarity, that attacking it frontally would be completely useless, a waste of time and energy she could not afford. The decree had been issued by a legitimate and internationally recognized government, at a time of war when such measures were generally considered acceptable, and for a purpose that many, perhaps the majority of French people, considered justified, maintaining the military discipline necessary to win the war. Simply arguing that the decree was unjust or disproportionate would not be enough. The judges would respond that wartime conditions justified extraordinary measures, that it was not for them to judge with hindsight decisions made under the pressure of events. Marie had to find another way, a more sophisticated approach that could bypass the problem of the decree's formal legitimacy, and instead attack its application or its compatibility with higher norms. The second document she examined with meticulous care was the French Code of Military Justice, an absolutely monumental tome of more than 500 pages in small print that regulated practically every conceivable aspect of military jurisdiction, from trial procedures to criteria for determining the competence of military tribunals, from rules on the admissibility of evidence to the rights of the accused. Marie spent entire weeks, which turned into months, studying it page by page, article by article, footnote by footnote, desperately searching for any clause, any principle, any phrase that could invalidate or at least significantly limit the application of Decree 348. She found several norms that seemed interesting and potentially useful. Article 123 of the Code stated with some emphasis, "In every military criminal trial, whatever the gravity of the alleged offense, the accused has an inalienable right to adequate defense and to the time reasonably necessary to prepare it." Article 162 stated with equal clarity, "All death sentences pronounced by military tribunals must be obligatorily confirmed by the Supreme Command before execution can take place." Marie felt a glimmer of hope when she read these articles. Perhaps Henri had not had a truly adequate defense. Perhaps the procedure had not been followed correctly. Perhaps there was a procedural violation that could be used to annul the sentence. But when Marie, with her heart beating hard with excitement and anxiety, requested and obtained access to the complete records of Henri's trial, preserved in the military archives after overcoming countless bureaucratic obstacles. She discovered with growing horror that both procedural norms had been formally, technically respected. Henri had had a court-appointed defense attorney, Lieutenant Dupuis. But as Marie discovered reading the trial transcript, which had been drafted in an extremely summary manner, the latter had not presented any testimony in Henri's favor, had not called any defense witnesses, had not contested the prosecution's evidence, and had spoken for less than 5 minutes during the entire trial, limiting himself to reading a brief generic appeal for clemency that the tribunal had completely ignored. The death sentence had been duly confirmed by General de Lattre de Tassigny himself, one of the heroes of the liberation, with a laconic telegram that Marie found chilling in its brevity. Sentence number 572, Soldier Marchand Henri, confirmed. Execute immediately. The system had functioned exactly, perfectly as it was supposed to function according to the rules that governed it. All the boxes had been checked, all procedures had been followed, all formal requirements had been met. And this was precisely the deepest tragedy, the fact that such a blatant injustice could be perpetrated in full conformity with the law, that the system itself was designed in such a way as to make it possible, indeed inevitable, that a good man would die for having made a human choice. The third document that Marie tackled, and by far the most complex and daunting, was the Hague Convention of 1907 on the laws and customs of land warfare, an international treaty that had been signed by almost all European countries, and that presumably established fundamental principles on the lawful conduct of combatants during hostilities and on the appropriate treatment of prisoners of war. Marie had read in an academic article cited in a book on the history of international law that this convention contained important principles on the limits of states' war powers. She thought, hoped, prayed that perhaps it might contain some provision, some clause, some principle that explicitly limited states' power to execute their own soldiers without a trial that respected minimum standards of fairness and proportionality. But the Hague Convention proved to be an almost impenetrable labyrinth of diplomatic clauses written in formal and redundant 19th century language, full of vague formulations like, "The laws of war do not give belligerents unlimited power, and belligerents must respect the laws of humanity," that sounded noble, but did not specify what these principles meant concretely when applied to specific cases. Marie literally spent months, frustrating months, during which she more than once seriously considered abandoning the entire undertaking because it seemed too difficult, too beyond her capabilities, trying to fully understand the structure and content of the convention. Article 46 spoke of the right to respect for family life and private property. But when Marie carefully read the entire article in the context of the convention, she realized with disappointment that it referred exclusively to civilians in occupied territories during military operations, not to soldiers subject to the military jurisdiction of their own governments. Article 23 listed in detail the prohibited means of warfare, such as the use of poison, the treacherous killing or wounding of enemies, the unnecessary destruction of property, but said absolutely nothing, not even implicitly or indirectly, about court-martial procedures or the rights of the accused in military trials. It seemed another depressing dead end, another road that led nowhere. Marie felt despair growing inside her like a dark wave that threatened to completely overwhelm her. She had already spent 3 years of her life on this seemingly impossible search. She had exhausted most of her savings. She worked part-time as a typist to pay the rent, but she dedicated every free moment to study, to the point where she no longer had a social life, no friends, no interests outside of this consuming battle against a system that seemed impenetrable. She was about to definitively abandon the study of the Hague Convention, convincing herself that it had been a wrong idea from the beginning, when, one November evening in 1950, as the library was about to close and Marie was wearily gathering her notes preparing to return to her freezing apartment, she found almost by chance an obscure reference in a footnote of a German legal commentary on the convention. a dusty book that probably no one had consulted in decades. The note, written in academic German that Marie could barely decipher with the help of a dictionary, cited an interpretation given by the Permanent Court of International Justice, the predecessor of the International Court of Justice, in a 1926 ruling concerning a dispute between two Eastern European countries. The court had stated in a passage that seemed almost an obiter dictum, a passing observation not strictly necessary for the case decision: the fundamental principles of humanity that govern the conduct of war cannot be suspended or derogated, even in case of extreme military necessity, since such principles are part of the customary law of civilized nations and bind all states regardless of their internal legislations. That single sentence, almost hidden in a footnote of a book few had read, suddenly ignited a luminous spark in Marie's exhausted mind. If the principles of humanity in war could not be suspended even by military necessity, did that not necessarily logically mean that there was an absolute limit to the state's power to punish its own soldiers, even in wartime? Did it not perhaps mean that Decree 348, however legal and valid in appearance, according to French domestic law, violated a superior norm of customary international law that France was obligated to respect as a member of the community of civilized nations? Marie understood in that moment, with a sudden and almost painful clarity, that she had finally found the key, the theoretical approach that could work. But she also understood with equal clarity that she desperately needed qualified help. She could no longer proceed completely alone in this search. She urgently needed someone who truly understood international law, someone who could take her raw intuition and transform it into a solid, rigorous, convincing legal argument, capable of withstanding cross-examination in a court. She methodically began writing letters to professors of international law at various French universities, to retired judges who had published articles on related topics, to anyone in the legal community who might have the necessary experience and, more importantly, the willingness to listen to the story of a woman without credentials who was trying to overturn a military sentence that had become final. She wrote dozens of letters, each carefully personalized, explaining her research, attaching copies of relevant documents, begging for even a brief meeting. Most of the recipients never responded. Some responded with kind but firm letters explaining they were too busy, or that the case was outside their specific area of competence, or simply that they did not believe there was any legal possibility of success. But, in the hot summer of 1951, when Marie had almost lost all hope of finding an academic ally, she received a letter that would completely, irreversibly, change the course of her battle and her life. The letter came from a man named Julien Favre, an associate professor of public international law at the University of Lyon, specializing in humanitarian law and human rights, who had by chance read about Henri Marchand's story in a brief human interest article published in Le Dauphiné Libéré, a regional newspaper that had dedicated half a page to the case of the stubborn sister who won't give up. Favre's letter was written in precise and elegant handwriting, and the tone was cautious, but genuinely intrigued. He wrote, "Miss Vidal, I have read with great interest about the injustice suffered by your brother and your extraordinary perseverance in trying to obtain posthumous justice for him. Your dedication is truly admirable and speaks of a character of great moral strength. However, I must warn you with complete honesty that the legal path you are pursuing is extremely, perhaps impossibly difficult. The precedents are not favorable, and the prevailing legal doctrine on state sovereignty makes it very difficult to contest decisions made by legitimate governments in wartime. However, and this is why I am writing, I believe that your intuition about the possible relevance of the Hague Convention and customary international law merits more thorough and rigorous analysis by someone with specific training in this field. If you wish to meet with me to discuss the case in greater detail, I will be in Paris next month to participate in an academic conference on the European Convention on Human Rights. I would be pleased to devote some of my time to you. Cordially, Julien Favre." Marie read that letter 5, 10 times, initially unable to believe what her eyes saw printed on the paper. Finally, after 4 long years of intellectual and emotional solitude, after 4 years in which no one in the legal or academic world had taken her seriously, she had found someone, a true expert with solid academic credentials, who was willing not only to listen to her, but to seriously consider her ideas as potentially valid and worthy of further investigation. The long-awaited meeting with Julien Favre finally took place in a small, quiet cafe near the Pantheon, one of those typical Parisian bistros with marble tables and waiters in black aprons. On a rainy September afternoon, when the sky was gray and the air had that particular autumn smell that announced the end of summer. Favre was a man in his early 50s, with gray hair carefully combed back, glasses with thin frames, and tired but deeply kind eyes that suggested a person who had seen much pain in the world, but had not lost the capacity to empathize. He listened to Marie in complete silence for almost an hour as she told the entire story from the beginning, from Henri's death to the appeal sentence that had confirmed the legality of the execution, from her decision to study law on her own to the documents she had found in the archives, taking methodical notes in a black notebook with a leather cover. When Marie finished speaking, emotionally exhausted from the effort of reliving all that suffering, Favre remained silent for a very long moment, thoughtfully staring at the rain that beat insistently against the cafe's fogged window, lightly drumming his fingers on the table. Then, slowly, with a measured voice that carefully weighed every word, he said something Marie would never forget. "Miss Vidal, I must be completely frank with you. Your case, from the standpoint of positive law and force, is juridically almost impossible. The probabilities of success, calculated rationally, are extremely low. But it is also, and this is equally important, morally absolutely necessary. Someone must raise these questions. Someone must challenge the idea that the state has unlimited power over its citizens in wartime. And this contrast between juridical impossibility and moral necessity makes it a deeply, intellectually interesting case for someone like me, who has dedicated his life to studying how law can evolve to better protect human dignity." Favre went on to explain to Marie, with the patience of a professor accustomed to making complex concepts accessible, what was the fundamental problem that made the case so difficult: the sacrosanct principle of national sovereignty. According to the fundamental principles of international law of the time, principles that had been established in the peace treaties of the 17th and 18th centuries and were still widely accepted, every sovereign state had the absolute right, not limitable by external authorities, to judge and punish its own citizens according to its own laws, especially in matters of national security and military discipline. The Hague Convention, Favre explained, had never been interpreted by any international court or any authoritative scholar as a significant limit to this sovereign power. Its principles of humanity had been applied mainly to relations between belligerent states, to the protection of enemy prisoners of war and civilians in occupied territories, not to the internal relations between a state and its own soldiers. The famous Nuremberg and Tokyo trials, which had been concluded only a few years earlier and had attracted the world's attention, had indeed established that there were crimes so grave as to justify the intervention of the international community and the trial of individuals, even if they had acted following orders from their governments. But these were specifically crimes against humanity, genocides, massive war crimes committed by defeated totalitarian regimes, not internal judicial policy decisions made by a legitimate democratic government like post-war France. Directly attacking Decree 348 necessarily meant arguing the radical and controversial position that there existed a higher law, a norm of international law that limited the sovereign will of the French state even in matters of military discipline. And in 1951, this was a revolutionary idea, dangerous to the established order, that would encounter fierce resistance from state institutions and most of the legal community. But Favre, and this was why he had agreed to meet Marie, also saw a unique historical opportunity, a window of time that might not reopen for generations. Post-war Europe, still traumatized by the horrors of World War II and the abuses perpetrated by totalitarian regimes, was slowly building a new international legal order based on fundamental human rights. The European Convention on Human Rights had been solemnly signed in Rome only a year before, exactly on November 4th, 1950, although it had not yet formally entered into force, because not all signatory states had completed the national ratification process. That convention, the fruit of years of complex negotiations among countries with very different legal traditions, contained two articles that seemed directly relevant to Henri's case. Article 2, which guaranteed the right to life and established that no one could be intentionally deprived of life except in execution of a capital sentence pronounced by a tribunal in conformity with law, and Article 6, which guaranteed the fundamental right to a fair trial before an independent and impartial tribunal. If Marie, with Favre's help, could convincingly demonstrate that Henri's summary trial had violated these fundamental principles, that his execution had been disproportionate and inhumane according to the standards that Europe itself was now formally adopting, perhaps she could open a significant breach, a crucial precedent, in the apparently impenetrable wall of absolute national sovereignty. The Marchand case could become one of the founding cases of the new European human rights law. But of course, there was a crucial legal problem, an apparently insurmountable obstacle that Favre immediately identified. The European Convention on Human Rights, like practically all international treaties, had no retroactive effect. It could not be legally applied to events, even unjust and tragic events, that had occurred before its entry into force. This was a fundamental principle of law, known in Latin as lex retro non agit. The law does not act backward, and it existed to guarantee certainty and predictability in the legal system. This clearly meant that Marie could not simply directly invoke the European Convention as a basis for annulling the sentence against Henri, which had been pronounced in 1945, 5 years before the convention was even signed. The only possibility, Favre explained with some emphasis, was to demonstrate something much more complex and ambitious, that the principles contained in the European Convention were not new, had not been invented in 1950 by the diplomats assembled in Rome, but reflected and codified customary norms of international law that already existed, that were recognized and respected by the international community already in 1945, at the precise moment of Henri's execution. In other words, they had to demonstrate that the decree that killed Henri was illegal even according to the legal and moral standards of the time when it was applied, not just according to the standards that Europe would adopt years later. This would be the greatest intellectual and practical challenge of Marie's life. Favre explained to Marie, using examples and analogies to make extremely technical concepts of public international law comprehensible, that to demonstrate the existence of a customary norm of international law, recognized as binding by states even in the absence of an explicit written treaty, they would have to satisfy two requirements that international doctrine and jurisprudence considered necessary. First, they had to gather concrete, documented, verifiable evidence of a widespread and substantially consistent state practice over time. They had to demonstrate that many states, not just one or two isolated cases, had actually limited the use of the death penalty in their courts-martial, had adopted procedural safeguards to protect accused soldiers, had recognized in their legislation or in their tribunals' decisions that there existed a principle of proportionality even in the realm of military justice. Second, they had to demonstrate the existence of opinio juris, a technical Latin term indicating the shared conviction of states that such practice was not simply a discretionary political choice or a matter of convenience, but was legally obligatory, derived from an international obligation that could not be ignored without violating international law. They had to find statements by governments, opinions of authoritative jurists, sentences by national or international courts that explicitly recognized the existence of a superior principle of humanity and proportionality that limited states' power to execute their own soldiers even in wartime. And of course, all this had to be documented with irrefutable written evidence. It was not enough to refer to abstract principles or general moral convictions. Marie felt the enormous weight of that challenge physically crushing her, as if someone had placed a boulder on her shoulders. How could she, a woman alone with extremely limited financial resources that barely allowed her to survive month to month, gather evidence from government and military archives scattered literally throughout Europe? How could she access documents that were probably classified or buried in forgotten collections that no one had consulted in decades? How could she travel to a dozen different countries, each with its own language and bureaucratic procedures, to search for legal precedents that perhaps did not even exist? The entire undertaking seemed so titanic, so beyond the possibilities of any individual, that for a moment Marie seriously considered giving up, accepting that she had done everything possible but that some objectives were simply too large to be achieved by a normal person. But then she thought of Henri. She saw again in her mind the image of her brother that she had jealously preserved, a black and white photograph showing Henri in uniform with that gentle smile he had always had. And she thought of her mother who had died with a broken heart, carrying to the grave the undeserved shame of being the mother of a deserter. She felt determination return, stronger than before, burning away doubts and fears. She looked Julien Favre straight in the eyes and said with a firm voice that admitted no hesitation, "Tell me where we must begin. Tell me what I must do. I will do whatever is necessary. I will go wherever it is necessary to go. I will study whatever it is necessary to study. I will not stop. I will never stop." Favre looked at her for a long moment, studying her face, evaluating her sincerity and determination, then smiled for the first time since they had met, a small but genuine smile of respect and perhaps affection, and said, "Very well, Miss Vidal. If you are truly determined, then we will begin in Switzerland. The archives of the International Red Cross in Geneva contain thousands, perhaps tens of thousands, of detailed reports on violations of the conventions of war, on formal protests presented by Red Cross delegates to belligerent governments, on specific cases in which the principles of humanity were invoked to limit war violence. If there exists somewhere a clear documented precedent in which a respected international organization protested against the excessive use of the death penalty in courts-martial by invoking principles of international law, we will find it there. That will be our starting point.